Check, check. All right. Welcome to today's Planning Commission meeting, February 13th, 2025. I call the meeting to order at 9:01 a.m. And can we please stand to do the Pledge of Allegiance? Can we get verification of legal notice? Thank you. Moving on, our consent agenda is to approve the minutes from January 23rd, 2025 Planning Commission meeting.
So moved.
Second.
Motion passes. So now we're moving on to public input. And for public input, any person may speak for 3 minutes about any subject of concern, provided that it is within the jurisdiction of the Planning Commission and is not already on today's agenda or scheduled for a future public hearing. And this one is for any other public input in any of the items that we're going to review today. We just ask the public and whoever wants to speak to legibly write your name and say your name when you come up to speak. So that being said, we are in public input, so anybody wishes to speak, we'll take a look in the Zoom room to see if there's anybody in there as well.
There's one hand.
Okay. All right, Donna, we are in public input, and we're going to see if we can unmute you. And you'll have 3 minutes.
Good morning, Donna Makowitz, Red Bed Audubon. Thank you for letting me share a few thoughts. We all know trees are vital to the health of Lake County and to people's lives. They provide food, oxygen, shelter, and they help fight climate change. With the fast-spreading severity of mob, or the Mediterranean oak borer beetle, in our county, we should remember not to move firewood and buy only locally. Also important is keeping our current unaffected trees, especially oaks, safe, and we should be mindful of removing healthy trees only when necessary and a safety issue. If you spot a tree you think has mob, take a photo and report it on the Clear Lake Environmental Research Center website at theclerk.org. And if a tree or shrub must be removed, mitigation replacement should be locally grown when available, and a species that would be native to Lake County specifically, not to California. And thank you for your time.
Thank you, Donna. And we will take our next item in about a minute. Oh.
Thank you, Chair. Mireya Turner, Community Development Director. Just wanted to take this moment to appreciate one of our recently former planning commissioners. Come on up here, Christina. Christina Price. Excellent. Christina served as planning commissioner from 2019 to most recently 2024, when she stepped down because she was elected to city council for the city of Lakeport. In those 5 years that she was here, it was very impressive to watch her grow into this role. She served as chair of the planning commission a number of times, and to see how she grew in her, what I think of as classroom management skills, which is kind of running a meeting, it was just really wonderful. And the staff was comfortable knowing that she was in control of the meetings. I appreciated her intelligence and her questions. And I would just want to give the other commissioners a moment to chime in as well. Yeah. Oh, and to watch her grow. There you are. Not done, Sam. To watch her continue to grow, actually, in her personal life, I think brought a richness to her understanding and her ability to analyze projects for the county. Okay, now I'm done. Thanks.
So Christina, I'm happy for you. I'm thankful for your service, your leadership, your dedication, and everything that you brought to the commission. We were in good hands with your leadership. Sad to see you go, but I'm happy for your new journey, so thank you for your time.
Hi, Christina. Good to have you back. Nice to see you. When I first joined the Planning Commission, I mean, you were already here for a couple years before that. And just having you on the board was, you know, it was really cool to be able to, I'm really out of it today.
It's okay. I gave you a warm comfort feeling. Huh?
Yeah.
I
No,
made
and
you feel safe.
yeah, well, the last meeting that we had, you weren't here, so we said goodbye to another commissioner
I
as well.
saw that.
So it was kind of good that we didn't have two at the same time that were leaving. So I guess I didn't know you were going to be here today, so I couldn't say something as well planned. So, but we miss you, and good luck on in city council and with everything that you have going on. I know you were always really busy, and you were still here doing this job as well. So thank you.
So I'm the newest member here, and when I came on, I watched how you ran the meeting, and now that I'm vice chair, I learned some things. I'm watching this guy here. But what a fun adventure for you to move on and spread your wings and do some other things in the realm of public service. So best wishes.
We may have some staff who wanted to share a few words, and then we'll hand it over to you.
That's cool. Thank you, guys.
Hello. So I totally want to call you Commissioner Price, but now you're Council Member Price, and that's amazing to see the growth that you have displayed, and you have provided so much information and growth for staff too, that I just wanted to take a moment to recognize you from our perspective. Thank you for everything that you've taught us and to allow us to grow with you during your time here. Thank you.
Wonderful. Did you have any parting words?
I mean, I'll never pass up an opportunity to speak. Thank you, Maria, Director Turner. It's been a while, so I got to see plenty of directors come and go, and I knew as soon as I saw that you were going to be taking this position, I could take a breath of relief for staff and for everything that you brought to the calmness and the procedure and structure that you continue to bring to staff. So I can't wait to see everything that comes out with your project 2050 and all the general plan stuff. I'm super excited. And as far as staff goes, I've had the chance to watch some of the beginning entry-level staff grow into associate planners going on to their positions and spreading their wings as well. So I'm also excited for you to be on the city's planning commission. So congratulations to you. To you guys, I know you guys are going to do a great job continuing to care about the future and land use, and having a variety of age and ethnicity and background really provides such a diverse commission, and that is why I feel like your guys' jobs are so important. So continue to do what you do, be out there for your community, and I'll be around. I'm easy to find. To the public, thank you for hanging in there, and I'm going to pass it off. Thank you so much.
Thank you.
I was going to give her a hug.
Sam's coming.
Thank you. All right, public, we'll get you guys going too. Don't worry.
Okay. We're going to train everybody here.
Oh, yay.
Come
Hurry
on,
up.
everybody comes
Come on,
down.
first photo. Come on, folks. It's going to go on my mantle. Yay.
Yeah. Oh, nice. Okay, I'm going to
Yay.
get that one right away. Hold on, I'm going to get one more. And let me get one more. Good. Good. Thank you.
All right, guys. Thank you. Have a great meeting. Good to see you guys. Oh, take care. As you go. Thank you.
Check, check. All right, and moving on to our 9:05 item. Public hearing continued from 10/10/2024 and 12/12/2024. Consideration of proposed major use permit UP 21-07, Little High Valley at 17870 Little High Valley LLC. And mitigated negative declaration IS 21-07 for approval of two A-type 3 outdoor commercial cannabis cultivation licenses and one type 13 self-distribution transport only license located at 17870 Little High Valley Road in Lower Lake. The APN is 012-061-03. And we have staff.
Good morning, Commissioners.
Good morning.
Waiting on the PowerPoint.
Share screen on green? Yeah. Okay, and it should be right there. Hear that? Press F5.
As previously mentioned, the project for consideration today is UP 21-07, initial study IS 21-07, Little High Valley. This project has been continued on December 12th. The item was brought before the Planning Commission, having been continued from the initial hearing date of October 10th, 2024. During the hearing, public comments were introduced into the record, which provided new information relevant to a potential violation of Chapter 30 of the Lake County Code. A continuation of the project was scheduled to a date and time certain today. To allow staff to address public concerns specific to grading without a permit. The permit request is for major use permit for two A-type 3 medium outdoor cannabis cultivation licenses consisting of 87,120 square feet of canopy within a 90,620 square feet area of cultivation, and one type 13 distribution self-transport only. This also includes a 3,500 square foot processing building that is equipped with an ADA restroom facility. And this building is for the processing, drying, and storage of cannabis. The parcel size is approximately 78.38 acres. The Lower Lake Community Growth Boundary is approximately 2.4 miles north of the project site. The zoning designations are for general plan, rural lands, and base zoning, rural lands as well. It is within the Lower Lake Planning Area in Supervisorial District 1. The site is accessed from a deeded easement from Little High Valley Road. A private native soil driveway averages 14 feet in width to the cultivation site from the security gate. The topography of the parcel is moderately to steeply sloped and is located on a volcanic ridge with elevations ranging between approximately 1,800 feet to 2,200 feet above sea level. Due to the location of the project site near the top of the ridge, there are no jurisdictional water courses on site. The project scope, including the 2 acres of outdoor canopy with the 3,500 square foot metal building for processing equipped with the ADA restroom, also includes 4 2,500-gallon water storage tanks for irrigation, 5,000-gallon metal water storage tank equipped with a 2.5-inch quick coupling for fire suppression, and an employee parking area with 8 spaces, including 1 space dedicated to ADA compliance. Existing uses and improvements on the project parcel includes a well, 4 5,000-gallon water tanks, interior roadways with the turnaround, and a security gate. The regulations reviewed for compliance include the Lake County General Plan, the Lower Lake Area Plan, the Lake County Zoning Ordinance, and California State regulations. The Lake County General Plan goals and policies reviewed include land use, economic development, and water resources. Within the Lower Lake Area Plan project analysis, the goals outlined were balanced development shall be encouraged, which includes improvements in public service capabilities to maximize community and economic development within Lower Lake, and comprehensive economic development efforts to benefit the community of Lower Lake shall be encouraged. Such efforts should involve a high level of community participation and input. This project, as proposed, includes the employment of 2 permanent employees and up to 8 employees at peak season. That would be during planting and harvest time. These employees would be local to the area. Major use permit for commercial cannabis cultivation is discretionary and is determined by the Planning Commission at public hearing. And all public hearings are noticed within the local newspaper and to also owners of the surrounding parcels within 725 feet of the project site. For this project, I included noticing to those that were within 725 feet of the access easement as well. This provides an opportunity for the community to have participation and input in hearings such as today's. The Lake County zoning ordinance was analyzed as well for Article 27, rural lands, which the site is zoned, and then also Article 27, uses generally permitted, which allows cannabis cultivation with a major use permit. Notification of this project was sent to local area tribes on May 7th of 2021. Middletown Rancheria sent an email to the County of Lake indicating that the project was located within their area of concern and requested further information. However, tribal consultation was not requested at that time. On October 23rd, 2023, the Middletown Tribal Historic Preservation Officer sent an additional email stating that he had conducted a site visit at the location and surveyed the project area. Tribal comments are attachment 8 to staff's report. For the California Environmental Quality Act, a mitigated negative declaration is the proposed CEQA environmental determination for this project. All identified impacts can be reduced to less than significant with mitigation measures. The public comment period for the circulation occurred from August 8th, 2023 to September 7th, 2023, and the mitigations are outlined in staff's report attachments 2 and attachments 4. The initial study found that the project could cause the potential impacts to the following resources: aesthetics, air quality, biological resources, cultural resources, hazards and hazardous materials, hydrology and water quality, noise, tribal cultural resources, and wildfire. A point of interest for this project is based on the continuance at the last hearing. On December 12th, 2024, the public hearing continuance for this project was heard. A new public commentary was received during the meeting, including concerns of violation of Chapter 30 of the Lake County Code for grading. A continuation of the project was scheduled to a date and time certain, which is today, to allow staff to address the public concerns specific to grading without a permit. On December 18th, grading and stormwater inspector accompanied Planning Division staff to assess potential violations of Chapter 30, the Lake County Grading Ordinance. The findings from this inspection are documented within Attachment 11 to the staff report, and although ground clearing was observed between 2004 and 2005, and again in 2020, interviews with property owner Mark McDonald and project manager Travis Listenby corroborated that this clearing was essential for facilitating access to remove debris left on site from abandoned vehicles from the previous owner of the location, as well as the installation of a permitted well and its associated utilities, which are exempt from grading regulations under Section 17.4.13 of Chapter 30. The cleared area demonstrated no signs of soil disturbance greater than 6 inches below the original grade, with no evidence of vegetation clearing exceeding 5 inches in diameter at breast height. No violations of Chapter 30 of the Lake County Code were identified by the stormwater and grading inspector at that time. However, a zoning clearance was required for the installation of the well utility water tanks. The zoning clearance ZC 25-04 was subsequently issued on January 15, 2025. The biological assessment summary and conclusions, attachment 6 to the staff report, identifies the previous cleared areas and vegetation regrowth with no special status plants or animals being observed. This supporting staff's findings. Within 1 mile of the proposed project are 1 approved and 0 pending projects, and within 3 miles of the proposed project are 12 approved and 6 pending projects. The recommendations for this project are to adopt mitigated negative declaration initial study IS 21-07 for use permit UP 21-07 with findings found in the staff report. Major use permit recommendations are to approve use permit UP 21-07 with the proposed conditions of approval with the findings found in the staff report. It is also important to note that the applicant and their consultant are present in chambers today. Additionally, I did speak with some neighbors of the project site this morning, and they advised that a green sheet item that was added from the last hearing is not included into public comment. That comment was from David Hall, an engineer, and at the last hearing, the commission did recognize that they had received that comment at that time. And I'm available for any questions or comments that you may have.
Thank you, Mary. Is there any questions from the commission? Should we move on to? No questions? Okay. If the applicant would like to come up and say anything, you guys are welcome to.
I am Mark McDonald, and I am the applicant on this project. I own Inland Properties, which is a land brokerage specializing in Lake and Sonoma County land. And we've been in business for 35 years and sold hundreds, if not thousands, of acres of Lake County land. And so I consider myself pretty much a land expert and know my way around land. This particular property, the 78 acres, Little High Valley, I purchased, I think about 6 years ago, 6 years ago. And it came with its challenges, has been noted. It was, there was a lot of debris there that needed to be removed, some other challenges. But we did that promptly, and now that that site is very clean, very, we keep it, it's under surveillance, and there's no activity ever there. So That's what we've done. Now, it's also been about 4.5 years since we've been in this process, in the permit process. I think we started in mid-2020 and complied with everything that we're supposed to comply with, done everything we're supposed to do, and just been patiently awaiting for this kind of time when we'll possibly be approved. It's a long time. As I indicated, I'm a land expert, and I have done some development, and 4.5 years is pretty normal for a subdivision, major subdivision, but for just to put a few plants in the ground, it's been a struggle, that's for sure. As mentioned, Travis Lisenby is going to be the project manager. He's got a lot of experience. I've known him for many, many years. I sold him his first piece of land 15, 17 years ago, something like that. And he's has very much impressed me over the years as his ability as a canaculturist, I would call him. And he's probably one of the best growers around here. And that's our intention for this project. It's not a mass project. We don't plan to do a lot of big volume, but what we want to do is to produce a quality product with as little impact as we can with the surrounding areas. One of the reasons that we've decided, I fell in love with this property when I first purchased it, because it's one of my favorite areas of Lake County, which is the Noble Ranch, Spruce Grove, southern Lower Lake area. It's just my first piece of land, I think, I ever sold on the Noble Ranch. I said, well, I'd live here for sure. And so that was one of the reasons why we chose it. But another reason why we chose it is it really conformed. Let me back up a little bit and say, because I've sold land for 35 years here, a lot of the land I've sold over the past few years have been to wannabe cannabis growers who wanted to get their permit and do it legally. So I've been very conscientious of the process that Lake County would like to see for permitted projects. And I know some of the things that you people want to see, and that is a discrete location, a location that's not in someone's face, not along Highway 29 or whatever. It is to be, as discreet as possible. And that's one of the reasons why we made the decision to pursue a cannabis permit, because this is it's absolutely perfect for a discrete site. It's also perfect for an agricultural site because it is a ridgetop, gets full sun. So we thought, well, that would be a great project that meets all the standards. As I've indicated before, we tried to be very sensitive to the neighbors. I know a lot of the neighbors are in opposition to this project, and we tried to accommodate them as much as possible. Travis is a very, very adept and able person. He's with equipment, so he's able to handle any kind of situations that may arise, as we've already exemplified. We've improved the road. The neighbors said they wanted the road improved, fine. And we will always continue to keep that road very passable and very nice. It's probably in the best condition it's been in 30 years. So that's our intention. Our intention is to be as cooperative and to be as discreet as possible. Travis doesn't work with a lot of different people. He has a small crew of people that he works with and has worked with over the years. So the comings and goings will be at a minimum. And like I say, we're not doing a mass operation up there. We want to develop a very superior product. So, we're very confident that any of the concerns that the neighbors may have in the future, we definitely want to satisfy them. One of the things that we developed when we went up there was the well, which is a very good well, 400 gallons a minute, excellent well. And some of the concerns from the neighbors have been, well, if you start growing all of this weed, you're going to run our wells dry. And there was an issue there at the very end of the drought. But of course, there was an issue of one well running dry. We provided water to that person, and now we're into the third year of normal kind of rainfall. So a lot of those aquifers now will be filled. So, and that's what we don't want any negative impact to neighbors at all. If there is a situation that arises, we definitely want to do. Travis is capable enough to do it. And that's what we want to be, is excellent neighbors. So that's pretty much my story. So we definitely are hoping for an approval today.
Thank you.
Good morning. My name is Trey Sherrill. I am consultant to the applicant. I just wanted to kind of go back over, this is the third hearing for this project, and I kind of wanted to go back over the timeline, how we got here today. During the original hearing, it was brought to the attention of the commission that a well on a neighboring property was not analyzed in the hydrology study. Therefore, a continuation was granted so that we could further look into that issue and see if there is any potential for impact to that neighboring well. We went back, spoke to Lake County Environmental Health and Department of Water Resources, and neither agency had any record of that well. And then it has since come to our understanding that the well is not on that property, and it's actually on an adjacent property that's further from this project site. But we still don't know that for certain. Another issue that was brought up during that original hearing was the condition of the road, and I'd like to direct your attention to the inspection report after the Lake County grading inspector came out and checked out the property for the potential for grading violations. He states in there, the access road to the site is well maintained with effectively constructed water bars, and no signs of erosion or structural failure were observed. So finally, I'd also like to kind of bring, Mark mentioned it a few times, talking about Travis Lisenby, who will be managing this project. Travis, I've been working with Travis for, since probably 2016. And he has a licensed farm. I helped him get a licensed farm off at the end of Jerusalem Grade. And even though he lives close to the start of Jerusalem Grade in Spruce Grove Road, it takes about an hour to get out to his licensed farm at the end of Jerusalem Grade, where this site is about 10 minutes from his house. And so therefore would allow him to spend more time with his family and be closer to home. And also, it's not quite the burden to access such a far away location. And want to direct your attention to some of the public comments that were received. One of them, being from Martin Gifford, who originally wrote a letter in opposition, but once he found out that it was Travis that was going to be managing the site, he rescinded that opposition. And then there was an email, and this happened prior to the first hearing. There's an email from Mark McDonald, the applicant, and to Mike Wink. There was a fire that occurred on that ridge line, not on this property, but on that ridge line. And Mark immediately emailed Mr. Wink, informing him that there was 20,000 gallons of stored water. He gave him the gate codes, told him exactly where it is, and encouraged him to use the water for fire suppression. And even stated that he wanted to make sure that water was definitely available to the neighbors should it be needed for fire suppression or any other needs. So I just wanted to present these like the history of why we've had the continuances, and then also from the public comment, the character of the applicant and the manager of this project. And I wanted to make myself available if you have any questions.
Thank you, Trey.
Thank you.
I have a couple of questions, if I may.
Yes, ma'am.
So you talk about the water. Wondering, how many plants are you anticipating to be planting in the 2 acres?
Now, that would be a question for Travis. When we're doing analysis for water consumption, we use an acreage of the, or square footage or acreage of the canopy area. That would be the area that's actually, being actively cultivated. And that is because, if you have really large plants, you're going to have fewer per acre. I'm going to throw out roughly like 500 per acre if you have very large plants. But if you're growing smaller plants, you can have as many as 2,000 per acre. But there's a difference there. There is really no difference in the amount of water they use. One large plant is going to use as much as 5 or 6 smaller plants, for example. But I know Travis is going to come up here soon to speak, and so I would ask that you ask him that question, and he could better answer that plant number.
Thank you.
Okay. Thank you.
Thanks. So I will be opening up public input, and just like to remind you guys to legibly write your name on the sheet up there and state it for the record, and then you'll have 3 minutes, so public input is now open. I think there's one on the podium, ma'am. Yeah. Yeah, sorry about that.
Oh, on this right here?
Yes.
Hi, my name is Elaine Brown, and I grew up in the 1970s as a child. I remember the 1960s vaguely. I had a cousin who was on heroin that he got out of it through Turning Point. We were educated a lot as children because our parents did not want to see us fall into that trap of drug addiction, and they did a fairly good job. And as an educator and we were taught that marijuana was a gateway drug. And I want to really state, I have 2 really good friends who I value highly on the opposite end of the table on this issue. So I just want to I know from my studies that marijuana suppresses one's desire, their desire, like ganas, the desire to do, to work. And I worked shortly with some gang-related students who were they were taking marijuana, and all they could talk about was their next hit. Because if you get that early on and it's accessible, that tends to be just like alcohol. It's something they can't get past. And it also lowers the ability for a student, say, at a party to say no to marijuana if offered, because you can't say, well, it's illegal. Usually that gives you a little bit of respect when you can step away, and that takes that away. That being said, do we want to be known as the county that I have heard, I don't know this for a fact, is one of the highest depression counties in California per capita? This may be a leading part of it, and just a lot of people not wanting to work and don't have that ganas or desire. So, and also, when I first came to Lake County in 2021, I did a little bit of investigation on the lake, and it is possible that herbicides going into the lake and runoff water is causing a development of the hydra. So I just think, as maybe parents and community members, maybe revisiting this explosion of the marijuana industry in our county, because maybe we want to be known for something else. Thank you for listening.
Thank you for your comment. Yes.
A moment while Thank you for the opportunity to speak. Can I go ahead and start?
Yeah, you want to just pull the mic a little closer?
Okay. Thank you for the opportunity to speak. I understand the process is taking a long time. I commiserate with that. It is taking a long time.
Sorry to interrupt. Can you say your first and last name?
Oh, I'm so sorry. I signed, but I didn't say it. Joni Henderson. I live directly adjacent to the property with the proposed grow operation. I commiserate with that this is taking a long time. It is. There's many issues that the neighbors have brought up that are not being addressed, and here we are again. We had, during the last public hearing back in December, a physical engineer, Brian Hall, wrote a paper. I noticed it's not included in public comment. I'm not quite sure why. I was told it was a green sheet. I really want to make sure you all see it. In there, he mentioned very specific times where the paperwork that has been submitted by the applicant is not in line with the law. It is not in line with the regulations. I'm really hoping that you have seen it. It's dated December 10th. Brian Hall, not David Hall, it's Brian Hall, by the way. To make sure you see it, please. In there, he offers evidence looking through the documentation. He's a physical engineer, and he saw, based on the satellite imagery, where this was cleared by Mark McDonald. And if you please look on the applicant's own documentation, you can see mature trees were removed. 5 inches is like this. On the satellite image, you can see these were mature trees. We were told seek was not required because trees were not being removed. Really? Look at your own documentation, please. I have documents I can pass around if you would like to see them, where you can see from their own documentation this area was stripped clear. Not from 2004, recent, after Mr. McDonald purchased the land. And I'm not quite sure what Mr. Elliott saw when he went out there, but that's clearly in the images. All the neighbors have testified to what we witnessed back in December of this clearing with heavy equipment. He said he did not see any evidence of erosion. I have some pictures where these water bars, as I believe he called them, that were placed on the driveway, it's causing massive erosion. You've got where it's eroding and then the big bump. Can you imagine what that happens to your vehicle when you drive over that? It's damaging our vehicles. Who's responsible for that? This was done with no permits, no grading permits. It's just being kind of forced on us. We did not ask. As he said, we asked for the road to be widened. No, we did not. This road is being widened for commercial purposes without, please show me where permits were applied for. Show me where the benefit of CEQA. There hasn't been any. I looked, I asked. There hasn't. Even when this was brought to the county's attention, they still don't have notice that this was cleared. And please, in Mr. Hall's letter, he cites where even in the application, some of the clearing that occurred wasn't included, and that would have required CEQA to have happened, a CEQA review. It didn't. So where is this following the rules? Please review this. I'm sorry, I'm a little nervous. I was told in the beginning that my homeschool with my children, you may recall from what I've testified previously, is it testimony when we're up here? I don't know, sorry. One public comment. My son is a cancer survivor and he is still undergoing treatments for related issues. We homeschool because of this. He has very serious issues. I was told that my homeschool, I fill out all the required paperwork with the state so they know he's not true.
I'll give you additional time so you can finish your statement.
Thank you, I appreciate that. I fill out all the required paperwork with the state. I have the paperwork. I was told that no, homeschool's not recognized. Daycares are recognized to have a 1,000-foot setback from the parcels, not just the buildings, from the parcels, from the grow parcel. That's the law. In Jonathan V. Superior Court of Los Angeles, 2008, this goes back a long time. This has been case law. California state ruled that homeschool is a species of private school. That's their wording. Please, please look this up. It is a species of private school. My affidavit acknowledges that this is a private school. That's why we do it. The part where it says that the California Office of Education doesn't have jurisdiction, it's stating they don't have jurisdiction over the curriculum we choose because they don't review curriculum. That's up to the parent in the homeschool. We do accredited program, but they don't, that's not part of their jurisdiction. What they do is recognize this is a homeschool and your child is not truant. It's acknowledging it's homeschool. Case law is acknowledging homeschool is a species of private school. So I ask, please, why is my home that has been, this isn't new, I'm not just suddenly doing it, why is my homeschool not offered the same equal protection that the 14th Amendment of the United States Constitution guarantees? My children are protected. There's 400 feet from my building, my home, my backyard is even less than that, to the grow property. There is no separation between parcels. It's supposed to be 1,000 feet. There's not. This is where my children go to school. We have to school this way for my children's health. This isn't just something being made up.
Ms. Henderson, would you like to wrap it up, or do you have unless if somebody in the public would like to give you their time?
Would you like to give me your time, Mom? She can't hear. Just a second, please. Could you give me your 3 minutes to speak? Would you yield your time to me? Or you could do it, Brent.
She doesn't have to stand up. It's okay.
Okay.
Yeah, we'll just start the timer for 3 minutes.
It's okay. She can't hear very well. Thank you for that consideration. There's also, and very important, as you all know, being part of the Planning Commission, that the area of our county was just reevaluated for fire risk, fire potential. The maps just came out recently, and we're still very high fire risk. This road it's not meeting the standards set forth by CAL FIRE's standard. Excuse me, I'm missing what the standard is. I believe it's 4290. I'm sure you're all very familiar with that. Is that right, 4290? Okay, thank you, sir. I appreciate that. It doesn't. It's a mile long. I have pictures where it's in places in my neighbor's driveway, it's like 11 feet. That's not for passing. There's ditches, there's rocks. It's a mile long. This road serves multiple families, and now we're adding more cars. What's going to happen if we have another fire in our area? How are people going to be getting out all these cars while CAL FIRE is trying to get in? They have widened a good portion of the road without permits, as I said, for this commercial operation, but other parts they have not. They don't have the right to do that. It doesn't satisfy the requirements for this standard. Show me where it does. Whose signature is signing off on this? Because it's putting my family at risk. We do not have what this standard is designed to do, afford us good egress in the event of an emergency. Who's signing off on this? I'd like to see the signature. I'd like to talk to them. I'd like to show them there's a giant rock, there's a ditch. Here's another place where there's a ditch and another ditch. How can you possibly pass 2 vehicles, a big fire truck with 11 feet? You can't, but we're being told, no, nothing here, and that the only issue from last time was the potential grading by Mr. McDonald. No, that was not the only issue that was brought up. Multiple issues were brought up in Brian Hall's letter. We reiterated it in our public comment time. It's not been addressed. I'm very confused by this. We also have the issue that was recently, that was recently a JCC Crandall versus the County of Santa Barbara. Let me make a side note. The easement passes multiple properties, and it's deeded in several places. It is not deeded where it crosses my property. I'm the last property owner before it enters their property. It's not. It's prescriptive. Nowhere has that been proven, that it's anything other than that. In this case, JCC Crandall versus County of Santa Barbara, it found that you cannot force a landowner to allow an illegal operation to go across their property. What they found, this is found in the case.
And I think that's the time. We're giving you 6 minutes.
Okay. So now someone else, can I come back up and finish?
If you had somebody that another person that wanted to give you? Okay, we'll do the timer again. 3 minutes.
Let me open back up.
All right, you can continue.
Okay, thank you. I'm just finding my spot again. What the court looked at was not the illegality of marijuana or not. It's federally illegal, we know that. What they looked at was whether or not a property owner had the right to say, no, I don't want you crossing my property on this easement for commercial cannabis growing, it's illegal. They decided that the property owner could say no. That was the decision. That is on the books. Again, that was JCC Crandall versus County of Santa Barbara. And I'm so sorry, I'm nervous, so I'm probably not presenting all the information that I should. Many Californians expect that because cannabis is legal in California, that automatically means that you have to allow this access. Well, the changes in the easements, it can't change from the mode and manner of when it was originally established. That would change that. You can't do that without the permission of the property owners. And as we testified last time in December, no, we do not give the permission for this across our collective properties. We don't. So the major takeaways on this particular issue, since cannabis is illegal federally, a simple access easement as currently described in the ordinance is not sufficient to allow the cannabis transport across property the operator does not own. For where the easement is needed, the applicant must have permission from all landowners to allow to permit the commercial cannabis activities. The county cannot punt the issue or claim it's a civil matter outside the responsibility, since the county requires roads to be in compliance with multiple ordinances and explicitly requires easements to meet a certain standard. That also brings in what we were just speaking of with the CAL standard. An old easement, one that was granted prior to the legalization of cannabis in California, is not sufficient, since the mode and manner of use has changed dramatically. Again, they're trying to widen our roads for this commercial operation. We do not have permission. We did not ask him to do this. As far as with the CAL standard, if I may revisit that, if the road is less than 20 feet wide, it doesn't meet the standard. The road is not. I have pictures I can show you. If it does, show me where someone has signed off on it. Is the road a dead end? Yes, it is. It ends on his property. And it's right at a mile, which puts it right in, I think it's actually a little more than a mile. If the grade of the road in any way is greater than 16%, there is a very long hill that had the water bars installed because of the water coming down the road rushing. It's greater than 16%. Show me where it's not. Are there sharp turns with a radius of less than 50 feet?
That's the other
Yes,
3
there
minutes.
are.
Sorry to interrupt.
Okay. Thank you for letting me continue to speak.
Yeah, of course. Is there anybody in the Zoom room that would like to speak on this item? All right, Maria Khan, I believe you're coming up next. You'll have 3 minutes. Please state your name, first and last name for the record.
Hi, thank you. My name's Maria Khan, and I'm standing in support of the neighbors that do not want this operation in their backyard. I've been reading through all the documentation, and it looks very similar to how a grow in my neighborhood approached people, all friendly and nice, and helping them out and going above and beyond to do things before the plan got put into place and executed. And then they just disregarded huge elements of the plan. So they all have concerns about water, rightfully so. Somebody's well went dry. There's a concern, I'm sure, about the traffic on the road. I have an easement on my property, and I wouldn't want a business coming in and out, in and out, in and out. And we know with the grows that they operate at least 6 days a week, and they do like to work on Sundays also. So that's constant traffic for these people in their area. The fact that that property was graded by this organization who's very familiar with buying and selling property, and their excuse that it was necessary for them to remove the vehicles is kind of bogus, considering that all those vehicles got put in there without grading it. So therefore, they should be able to be taken out without grading it. And that was a huge area. That was overkill for any sort of grading. So I ask that you deny this project. They clearly have misled the people, and nobody seems to want it, rightfully so, because it will cause odor, congestion in traffic, a lot of things, and possibly even unseemly elements coming to the property that shouldn't be passing by a home with children. So I ask that you deny the use permit. Thank you.
Thank you for your comment, Maria. Are there any other hands in the Zoom room? I'm gonna take one more Zoom and then I'll come back to you. So Donna,
Hello,
state your first and
excuse
last
me,
name and
Donna Makowitz,
you have
Red
3
Bed
minutes.
Audubon. Thank you for considering denying this project until Brian Hall's submissions are addressed and a proper biological survey field study is completed and a new cannabis ordinance is enacted. If we examine the biological survey closely, there are many errors. The field survey performed by Pinecrest Environmental Engineering is outdated. It's almost 5 years old. September 2020 was an extreme drought year and does not reflect conditions accurately. It's discerning the birds of the chaparral were not mentioned. There are 11 breeding birds in this area, especially the wren tit. The wren tit does not migrate or even disperse far from its birthplace. It remains in one territory for life. In winter, you could find 9 bird species. There was no mentions of them or the other migratory bird species. The project area graded without permits removed chaparral and chamise plants. Chaparral and chamise have uniquely evolved over time to provide an almost unmatched benefit for our county. It supports hundreds of plant species that control erosion, protect people from landslides and flooding. Chaparral is an essential habitat and sustains diversity of life, and to have the amount of grading done to remove the debris is sad, and it's important to remember how important chaparral is, or in this case was. Thank you for considering denying this project as presented until a recent multi-season biological study is completed. Thank you.
Thank you, Donna. I believe we had somebody here in the chambers that wanted to speak. Don't forget to write in your name and say your first and last name for the record.
Yeah, my name is Bill Landers, and pretty much Joni's talked about all the details and whatnot that I wanted to talk about, especially with the Santa Barbara, County of Santa Barbara, and having their issues with the residential living there, and having the cannabis grow on that road and whatnot. So, but no, they're right. We did not give permission for Mark, Travis, all of them to grade the road, widen the road. The traffic is out there, and we've had people that have had to actually back up to let the other people through. We do have a problem with the water issues, and there wasn't one well that went dry, it was 2 wells that went dry during that one period. So we do have issues with that also. I don't want the traffic coming through there, because on my place is split up and the easement runs right through the middle of it. I do have grandkids, Joni has kids, that like to play out around there, and I just don't want all that traffic coming in and out. You're talking about eight vehicles during the time of the grow, and it's gonna last for a while. So that just doesn't seem right to me. We are talking about the wildfires and whatnot there, and they said they got 20,000 gallons for fire department. Okay, so let's say that Little High Valley, sometime or another, is gonna catch on fire. The road dead ends, like everybody says. It goes up there about a mile. If that fire catches up on High Valley Road, fire department is not gonna get to that 20,000 gallons. It's a dead end road, like I said. They're not gonna get up there. It's gonna go crazy. So, don't wanna say a whole lot more. I think a lot of it's been said. I thank everybody on Zoom and whatnot that put their input in on it. And hopefully you all consider this also. We are definitely opposing this whole thing, so I thank you all for your time and whatnot, and hope for the best.
Thank you.
Hello, I'm Travis Lisenby. I'm the project manager up there, and You said earlier that you're curious on how many plants we'd be growing up there. We get approved, we're just gonna start out with 20,000 square feet, so it'll be about 1,500 plants, to answer that question. As it goes with widening the roads, and they're saying, you know, we widen the roads, I never widened the roads, I brought in some base. And I continue to go up there during the rain to make sure that the wash bars are working correctly and diverting the water from running down the center of the road to wash it out. We obviously haven't been up there cultivating to use any water to drain anybody's well. We kind of just been doing this and hoping to move forward with the project. Is there any questions that you guys have for me?
I do on the planting. So on your documentation, you say that you're gonna have 2 acres when fully functioning. Is that correct?
Yeah, that's what the permit's for.
Right. And so with 2 acres, how many plants do you intend to, what is your estimate number of plants for that?
If we ever get up to the 2 acres, you would think, you know, about 2,500 to 3,000 an acre. Because we just, you know, you could start early in the season and grow big old 10-foot tall plants that take a lot of maintenance and manpower to grow. Or you plant at the end of July and grow a bunch of plants that are about this big that you just run a couple trellis nettings on. It's not all the labor intensive as growing, you know, big plants. You know, in the past it was big plants because it was all about numbers or plant numbers. And now we've figured out that a bunch of small plants, it's a faster turnaround. And that's the grow technique that I use.
So my concern is the amount of water that estimated water to be used. And I think the calculations in the documentation don't all match. But if you had 12,000 plants per acre.
No, not 12,000.
Oh, how many?
It would be 2,500, 3,000 an acre of little plants.
That's low density.
What do you mean?
2,500 plants per acre?
Yeah.
Okay. Well, I'm concerned about about the water use. And certainly noted, there's some well issues around, and they were noted that there are other projects in the aquifer that are either online or to be brought forward. Is that correct? Permits pending, I think is what you said. So.
Yeah, that well that we drilled there is, I don't know if you see, it's 400 gallons a minute. It's 220 feet or 320 feet deep.
Right, you have a 55
gallon a minute pump in there.
Correct.
Yes. So there's plenty of water, and as I told the neighbors in the past, you know, if I've give Bill water when he ran out, we weren't up there using no water. He used all 20,000 gallons that we had. I brought him a truckload too. I could say that the neighbors will never go out without water as long as I've got water, you know, so.
Okay.
And
can you speak to the questions about the road and permission or no permission? It's come up a couple of times.
You know, there was concerns that the road wasn't in the best shape, so I came and I brought some road base in. I never did no grading to make it wider. I cleared brush that was growing over into the roadway, so just cut back to the edge of where the road is. So
I think as much as the question about the process was permission given, and
I don't think
I'm just asking a question about, is that?
I don't think necessarily that permission needs to be given for a easement. We have a 50-foot easement going through there. It was just, I fixed it. It was a neglect on their behalf of why the road was washed out, you know.
Okay, so the lady who came up and spoke said that, talked about not giving permission over her property. So I'm
We,
just
we
trying to
never,
figure
we,
that out.
we don't pass her place going up to the property, so I never put no gravel on her property.
And are you finished with questions, so we can?
I'm just trying to just figure out, she made a claim, and so I'm just trying to sort out
No.
the validity of it.
Like I said, the road goes to the top corner of her property, which is about 100 feet from the gate. It cuts through the top corner of her property, but at no point do we drive directly by her house, or did I put any gravel on her property. I did on the rest of the road going down the mile of road. I fixed sections that needed attention. And like the grading guy said, I put storm water bars at an angle, not too flat, so it stops the water and goes over and continues to wash. There's an angle that you want to have it at where it doesn't go too fast, where it eats away what's there, but it also get the water off the road is how you keep a gravel road.
So there are no issue about prescriptive or given easements or any of those kinds of things?
No,
Commissioners? I can actually assist with that. The case that was cited by the individual public speaker, that is JCC Crandall in the county of Santa Barbara, that was a very recent case that was decided in an appellate jurisdiction that wasn't ours, but it would be an applicable case here. There is a business and professions code that requires that proponents of cannabis projects receive the property owner's permission. And up until this year, that was interpreted to mean that they receive the permission of the property on which they are cultivating, the owner of the property on which they are cultivating. This particular case, however, has interpreted to mean that the cultivator needs to receive permission from every property owner to which the project is impacting, and that would include easements. So if your commission were to find that this particular easement did not have the permission of the underlying property owner for use in a cannabis transportation, then that particular ingress and egress to the project would not qualify for the findings that you need to make, that the project would have access to a road. So there would have to be a different access to the project in order for those findings to be made if that one didn't qualify. If that makes sense, if I didn't make a hash of it. It would need to be.
So they need permission.
They would need permission for the easement. That doesn't automatically disqualify the project for approval, but there would need to be access to the property on which the project is located for an approval of a use permit. And if your commission finds that that was the only access available, then the project wouldn't qualify for a use permit because it wouldn't have.
Okay, so
access.
just to understand what you said, using this particular road that passes through various other properties, at this point in time, there would need to be permission from those property owners to use this particular road.
Correct.
Okay, I just need to understand that.
Yeah, any property that's impacted, according to this particular case, JCC Crandall, the court has interpreted the Business and Professions Code section to mean, that requires property owner permission to mean that they need property owner permission for every property through which the project crosses. So not just the property on which the grow exists, but also easements as well.
So if there were another way to enter to access the particular grow area that wouldn't have to go through any other properties, then it would be.
Or if the property, or if the proponent of the project were able to get permission from each of the
of course,
the easement owners, then yes, then they could use, or a different easement through a different property would qualify as well if they got permission there. But as long as they had permission of the underlying property owners under this case, then it would meet the requirement for the project, for having an appropriate and road access to the project, but that permission is required.
And do we know how many properties that it goes through? Oh, 2.
On GIS, it does look as though it leaves Little High Valley Road and proceeds through 2 different parcels before it gets to the project parcel.
Okay, thank you.
Any more questions for me?
No, thank you.
Thank you.
Oh, 1 second. What was that? Okay. We're gonna, we have a follow-up question in a second, so we'll get back to you guys.
So my question in regards to the court case, when is that specific court case date?
It was the beginning of this year.
Beginning of this year. So how does that impact our decision, since this has been quite a lengthy time with this project? One of the callers mentioned the biological assessment being done in 2020, but as this project was initiated in 2022, then it's still valid in my eyes. And so at what point does that ruling take effect in precedence on this case or this specific application versus the same thing with the biological?
So I understand. When rules change, there is a time frame, and you're correct, Commissioner, that when a rule changes, there's a sort of cutoff where people who relied on the prior rule can in fact continue as they were, and they are in effect a pre-existing non-conforming use, but it had to have been legal at the time that it began. In this case, there are no vested rights in this permit, and it's not that the rule has changed, it's that it was clarified by a court. So the rule has always been the same from then to now. It's just the court clarified what it meant. And so we would have to follow that case law, and we would have to apply it here for this project.
Okay, and then the second question, what protections do the homeschool have? Are there legal protections?
I would have to,
by the...
yeah, I would have to ask for a few minutes to look into that.
All right, so we'll continue with public input. Whoever would like to speak. Okay, thank you, Sam. Okay, so it looks like we're gonna take the Zoom person first. All right, Jay. We will unmute you and you'll have 3 minutes for your comment. And please state your first and last name for the record.
Hi, my name is Jesse Cood. I'm a Lower Lake resident and employee at Six Sigma. I'm representing Six Sigma in opposition to this project. Our property actually shares a corner with Spruce Grove Road and Little High Valley. And so it's in close proximity to our property, as well as the Hatoki Resort, which leases land from us. It's a high-end resort. We are concerned and disagree with staff's opinion that the negative impacts are less than significant, specifically on air quality and odor, noise, traffic, crime, light, water. And it seems obvious that the Brian Hall letter regarding the easement is a roadblock that can't be overcome. And we would support that decision. This has nothing to do with any attack on any specific people. I know Travis Lisenby personally, and I know he does good work. But there's some things that just can't be overcome with this project. Thank you.
Thank you for your comment.
Thank you. Joni Henderson again. Again, I live right adjacent to the proposed grow site. I did want to provide some more background information on the homeschool. As I said, homeschool is a form of private school that has been case law for about 18 years. That was Jonathan L. versus Superior Court of Los Angeles. Also, as it pertains to cannabis, there are 3 sections in the county ordinances where K through 12 school protections are mentioned. Article 27, page 27 to 29, section 6, outdoor cultivation not located within a greenhouse is prohibited with 1,000 feet of any public or private grades K through 12. Article 27, page 27 through 120, that's section 5. Commercial cannabis cultivation exclusion areas. Commercial cannabis cultivation is prohibited within 1,000 feet of the following areas of use. Any public or private school, grades K through 12. Article 27, page 27 through 155, section 25. No cannabis manufacturing shall be located within 1,000 feet of the following that is in existence at the time the permit is issued. We've been homeschooling for a few years. He's been diagnosed with cancer in 2017. This isn't something new. So let me continue. No cannabis manufacturing shall be located within 1,000 feet of the following that is in existence at the time the permit is issued. Not the application. Any public or private school grades K through 12. The distance specified in this section shall be horizontal distance located to the parcel where a public or private school grades K through 12. May I hand a picture? Is that allowed? I used Google Earth and the measurement just to give an idea. This is my house, and of course the backyards, the yards are part of the school, to the gate, which is the property line that I share. Realize there's no separation between our parcels. I'm only there's supposed to be 1,000, excuse me, thank you. Supposed to be 1,000, there's not. I'm just giving you guys an idea of how close my home is. It's 400 feet. The section of the road, as a side note, that passes over my property is over 600 feet. Allow me to continue, please. In Article 68, schools are defined as this, where the issue lies. Okay, when I was told that, when I submitted comment that no, it doesn't apply, yes, it does, and here's where I think they're grabbing straws and there's an error. Article 68, page 68 to 38, definitions, section A. School, for the purposes of cannabis regulation, school means any public or private schooling providing instruction in kindergarten or any grades K through 12, inclusive. But here's the odd part. Somebody put in there, but does not include any private school in which education primarily... Oh. Can I finish my thought?
Finish your statement, please. Yeah.
Okay, thank you. Education is primarily conducted in private homes. It cites Ordinance 3709, 12/11/2018. Well, I think this is a typo. I think it's 3709. And when you review 3079, there is no evidence that anywhere that it's talking about homeschool. So how did that get in there? It's not in the ordinance. Please review that. And plus, how does it make sense that we're protecting daycare, other schools, but not homeschools? Homeschools are recognized as a private school by the state. We file affidavits that recognize you have filled out your affidavit recognizing homeschool. Homeschool is homeschool. It's recognized as a private school and deserves the protections. Why would we not protect children? We know, as a teacher just testified in the beginning of this, there are impacts to children. That's why the 1,000-foot setback. But we're not going to protect my children? He already has health issues. That's not equal protection under the law. It doesn't even make sense that you would exclude homeschools. No one else does. Other counties, because I looked, Sutter County goes as far as to say anywhere children gather. So a known place where children gather, parks, public places where they're not permitted. It's a park. It has to be within 1,000 feet setback from even that. They don't require that it has to be an official. It's to protect the children. We know there are impacts on health. Please, listen to this. I also have some more pictures. I mentioned them, but I didn't hand them in. I have dates. These are from Google Earth, showing 2019, the site with lots of trees, and in my home adjacent, big trees, okay? And also from the paperwork that the applicant submitted showing trees, it's from their own paperwork, and then showing the clearing of the trees being gone April 2021. That is very much within when they're working on this site for clearing for the cultivation. It didn't occur in 2004, and that's where this is all from. No, they cleared it again. May I hand these pictures in? Is that okay?
Yeah.
Okay, and I also have pictures showing the mechanical grading with tractors. Okay, tractors. I also have pictures showing the width of the road. This particular one is right in front of Bill's house where we said it's very, very narrow. It's 11 feet. This is one showing the water bars that they've put in. This was last fall when the man, Ted Elliott, I believe, drainage man came out. I'm so sorry, I'm missing his title, but he came out to investigate grading and said there was no erosion. See, there's leaves still on the trees. This was in November, well before he came out and investigated. Okay, erosion on the road. There is definitely erosion being caused. Thank you for letting me continue.
Thank you. Do we have anybody else in the public that wishes to speak?
Hello, Trey Sherrill, consultant to the applicant, and on behalf of the applicant, I would like to request a continuance to a date uncertain in light of the JCC Randall case so that we can review it.
You said date uncertain?
Yes, please.
So we'll keep that and then we'll make a motion. Thank you.
Thank you.
Council, were we able to get an answer to that question regarding the, was it the homeschool?
Yeah, it was homeschooling. I'm going to need a little bit more time, probably about 10, 15 minutes, maybe if I can find it. There are, our ordinance does in fact exclude schooling that is primarily done in a private home. In the definition of, from the definition of school in relation specifically to cannabis activities that are permitted under the zoning ordinance. The state rules that I have reviewed thus far do also have that exact wording in relation to school definition, that they exclude schooling done primarily in private homes. So the state thus far has been in the cannabis sections that I have reviewed, has excluded private home schooling done in private homes from their definition of school for setbacks and other criteria. I mean, and other requirements for schooling setbacks and protections. So thus far that I have seen, homeschooling is not included in the state definitions or the county's definition in relation to cannabis.
Very well. Another question that I had regarding that was when the applicants apply to the state for their cannabis license, do they do like a search to see what is allowed or if their permit is allowed, knowing that that school or that home has been registered as a homeschool for a few years? Does that go?
We do not have access to any roster of a homeschooling. We do daycare proximity checks because we can get that roster sent confidentially from the state. When we're not aware of any similar roster for homeschools.
Okay, thank you. All right. Any other questions from the commission? So we'll continue with public input. And if there's anybody in the Zoom that would like to speak? No Zoom. I believe we have someone here in the chambers.
Yeah, how's it going? My name is Will Peterson. I'm the local water well driller. And hopefully I can clear up some of the water question issues you guys might have. This well was drilled during one of the worst droughts we've had since the 70s. And during that drought, it was producing 400 gallons a minute. You know, that's pretty substantial, exceptional. I've drilled several wells around the area, and they've all seemed to do pretty well. So as far as the water running out, if that's an issue, I don't think that's gonna be the case. So water has to do a lot with geology, and the geology of this area is volcanic. And that particular peak is the only volcanic peak around until you get over to the Noble Ranch area on the other side of Little High Valley. And the volcanic areas generally produce a lot of water because the rock is porous and it leaches very well, recharges very fast, and it's also connected to the other volcanoes, in my opinion, like Mount Lassen. So a lot of those volcanic areas, the water travels through the cracks in the rocks. It's not like a big lake down there like everybody thinks it is. So the water's coming from somewhere, and it's usually coming from the Sierra Mountains and trying to drain out through the ocean. That's why Lake County has a lot of water. If you go drill in Mendocino County, you don't ever get wells like this unless they're in the valley floor areas. And valley drilling is totally different than mountain drilling. So I think the well is going to yield a lot of water for a long time. And on a side note, as far as the personal integrity of the characters involved in the project, if the neighbors' wells were to run dry because of them, I can almost guarantee that they're going to get a water truck, build a line, or something to help the neighbors out. They're not just going to let them, suffer. So that's my personal opinion on the matter. Do you guys have any questions for me?
No questions?
No.
Yeah, thank you very much for coming up here and giving us your expertise on well drilling. Thank you.
All right.
I believe we have
Yes, I'd like to
statement.
speak again. I want to address one issue that's come up.
State your first and last name one more time.
Say again?
State your first and last name one
I'm
more
sorry.
time.
No, I'm Mark McDonald. I'm the applicant. I do want to address one issue, and that is a lot of the neighbors have been saying that they did not give us permission to maintain the road, which is essentially what we're doing. And I just want to let you know that the easements that go up to our property all provide for maintenance. You don't need anybody's permission to do maintenance. Both easements, or I think there's 3 easements altogether, and they all provide for, most of them are 50 feet in width, so we could widen it if we wanted, but we didn't. And we don't need permission because the easements provide for road maintenance. And speaking of permission, since this Santa Barbara ordinance or case has come up, yes, as Trey indicated, yes, I do request a continuance for us to seek legal counsel to really review that and make sure that we're in compliance with everything it stands for. Okay.
I'm going to take another look to see if there's any other comments. We see none on Zoom, and I believe that was everybody here in chambers. So I will be closing public input for this item and bringing it back to the commission for action or any other comments that we might have.
I think if the applicant is asking for a continuance, I'm okay with that. What is the process for that?
So in this case, your commission has several options. You can take the options that you would have normally before you to a motion to approve, a motion to deny. If you do make a motion to approve, I would ask that you that you provide your findings so that we would have that in the record. Same with the motion to deny. And you would also have the option of moving to continue. And you have you may move to continue to a time and date certain, and you may move to continue for not a time and date certain. And then if that latter is what you choose, then staff will renotice when the item comes back to you.
I guess the concern I have is I don't see us getting past the permission of the easement of the property owners in opposition. And I think we need to consider denying this project and it being appealed to the Board of Supervisors for them to make the decision. Otherwise, it's gonna I feel like it's gonna continue to go on and continue to go on. So that would be, my thought. I would definitely wanna support us as a commission together to make a decision. So if the chair is in consensus with a date certain, I'm fine with that as well. I just don't feel like we're gonna get to a decision in this body right here.
Yeah, I believe they're taking the motion that the applicants wanted to a date uncertain. That could work, but like you said, the main issue would be that one, to get that figured out about the easement. And that's the same thing, if that is, if that permission is not gonna be granted, then there's no point in, continuing to move on, kick this project down the road, again, that would be like a fifth time. So I also agree with, your comment on that. So,
Would you like to make a motion?
I think we need to maybe take a break and get a motion that's gonna be adequate, that addresses, if staff can help us with that.
Yeah.
I'd appreciate that. Let me take a 5 or 10 minute break.
all right, so we'll take a 10-minute break. It is 10:30. We will be back at 10:40 a.m. Thank you. Yeah. All right, we will be calling the meeting back to order at 10:40 a.m. And we had just finished closing public input, and we are going to be making a motion for this project.
I can give an update on the homeschooling issue. So the state of California, under the Business and Professions Code, which is where the commercial cannabis code section is found, as opposed to, say, the medical marijuana section, which is in the Health and Safety Code, does in fact provide for a setback for schools. It is 600 feet. They do give the authority for local municipalities to increase that if they choose. It does not, as far as I can find, provide a definition for schools, but it does cite the Health and Safety Code section for that particular. So California Business and Professions Code 26054 is where the setback for schools can be found, and it does cite the Health and Safety Code section 11362.768, which is the Health and Safety Code section related to medical marijuana setbacks. And that does provide a definition, which is the same definition as that the county has, which is that schooling in a private home is excluded from the definition of school. However, it may be that it doesn't specifically. Business and Professions Code does not specifically cite that definition. It cites the measuring for the setbacks that are put in in the Health and Safety Code section. So it could be interpreted that the Business and Professions Code section requires at least a minimum of a 600-foot setback from schools. And I can do further research and see how that is being addressed in other counties. I wasn't able to find any cases that really dealt with that directly. But based on it right now, it looks as if the state is leaning in most of its marijuana-related or cannabis-related rules towards excluding schooling that is engaged in a private home. So, but if your commission wanted to be cautious, a 600-foot setback would be the requirement under the Business and Professions Code.
And the setback is to the parcel or to the cannabis cultivation site?
It said, well, it'll be measured based on the Health and Safety Code section, the 11362.768 section. Distance specified in this section, so this is that code section C. The distance specified in this section shall be the horizontal distance measured in a straight line from the property line of the school to the closest property line of the lot on which the medical cannabis is located, or the cannabis is located, without regard to intervening structures. So from property line to property line, I think. Yeah, so closest property line of the lot on which the cannabis is located, and a straight line to the property line of the school. So.
Thank you for that, Council. All right, with that new information, I think we still have a motion, and I believe, or Commissioner Zoll.
So we'd like to grant a continuance. We want to ask, but we didn't want it to be undeterminate. We wanted to give it a finite period of time because we don't want people hanging about for, wondering what's happening. So we'd like to give a 1 month.
The next certain date certain.
For 1 month. When is our 1 month from here? March 27th? March 27th. So I would move that we would give a continuance to determine the issues that have been brought forth and bring it back on March 27th. Pardon me? 9:05.
I'll second.
I see a motion and a second. All in favor?
Aye.
Aye. All opposed? None, and the motion passes for a continuance for March 27th at 9:05 a.m. Thank you. All right, and moving on to our next item, our 9:20 a.m. Public hearing consideration of major use permit UP 24-14 Morgan Valley Temporary Met Towers to amend major use permit UP 22-06 Morgan Valley Temporary Met Towers to allow for a 6-year extension beginning August 25, 2024 and ending August 25, 2030. The applicant is Morgan Valley Wind Farm LLC, located at 25650 Morgan Valley Road and 10888 Rocky Creek Road in Lower Lake. The APNs is 012-014-02 and 012-014-08. And we have staff.
Good morning, Mr. Chair and Commissioners. My name's Laura Holmes, Senior Planner with CDD Department, and this morning for your consideration is Major Use Permit UP 2414 and CE 2422. The project has it's located on 2 parcels with addresses 25650 Morgan Road and 10888 Rocky Creek Road in Lower Lake. The agenda includes permit requests, project description, site description, project analysis, and recommendations. And the property owners are Larry Morrison and Harry Henderson. This is the vicinity map of the 2 sites that are highlighted in orange, approximately in the middle of the map. And as you can see from the line to the right of those orange boundaries, that's the Colusa County line, so it is a pretty remote site. And this is the site map that includes 4 towers that were approved in 2022. However, since that approval, 2 of those towers have been constructed in 2023, and they will not be moving forward with the other 2 towers. They will not be constructing those. These are the 2 towers that were constructed in 2023, one on the Morrison property and one on the Hanson property. The project description includes UP 2414, which would amend UP 2206 to allow for a 6-year extension to continue collecting wind data from the 2 Met towers. The extension would begin August 25th, 2024, when it would have expired, and will end August 25th, 2030. The August 25th, 2022 permit, staff report, and Planning Commission hearing video may be viewed at the following link. And the site description, it includes BLM lands to the north and east, private lands to the northeast, north, south, east, and west. Land uses include single-family and agricultural uses. The slopes are from 0 to greater than 30%, and the vegetation types are the different cypress woodland, letter oak, chaparral, and wild oaks, and other annual grasslands. The project analysis included looking at compliance with the project with Lake County General Plan, Lake County Zoning Ordinance, and the Lower Lake Area Plan. The project is in compliance with Gold PFS from the Chapter 6 of the General Plan for Public Utilities, and Policy PFS 6.1 and 6.2. for utility, the setting of utility. And the project is in compliance with Article 60, Section 216020 for the amendment of the previous permit. And it is in compliance with Objective 5.1A for orderly growth and development to encourage within Lower Lake area by focusing on higher intensity development within the community of Lower Lake, while lower intensity land use patterns are encouraged in the remainder of the planning area, which would be in this remote site. And policy 5.1C-1, land use planning decisions should encourage the efficient and cost-effective development of public services in the planning area. The project relies on the previous CEQA document, which was an exemption under 15303E, Class 3, new construction or small conversion of small structures. And staff recommends that the Planning Commission take the following actions. Approval of the major use permit, UP 2414, based on the findings in the staff report. And that is the end of the presentation, and the applicants are here to answer any questions you may have, or I am here as well, of course, so.
Thank you very much, Laura.
Mhm.
Do we have any questions from the commission?
Just the one that came in, a letter from public, landowner, are there gonna be electrical lines above ground?
No, this is a tower, and maybe the applicant can answer about electrical lines.
My name's Brandon Wolter. I am a project developer on behalf of the applicant. Write my name down. There is no electrical lines for this specific use permit associated with these towers. They are monopole towers, as shown in the presentation that our guide. Those are not electrical lines. Those are simply for keeping the tower upright. So no, there's not above ground electrical lines associated with this major use permit.
So the previous towers are not anything to do with this current application or any part of your guys' operation?
I'll just stay up here. My name is Brandon Wolter. The towers are already constructed. So we received a permit in August of 2022 to construct these towers. They have been in operation since May of 2023. This permit is simply seeking to extend the permit timeline for an additional 6 years as provided for in the conditions of approval in the original permit application, and permit conditions of approval, that is, yeah.
So, one question. So in the, what is it, like a year or so that it's been fully operational?
Yeah, like a year and a half-ish, yeah.
Okay. And how effective are they, or what kind of what do they help in determining, you know, wind speeds and for our GPSs and stuff like that, or kind of give us a little kind of what they're used for?
Totally. So they're used for monitoring wind speed, direction, temperature, pressure, general meteorological data, and we, you know, it's collecting data to evaluate for a potential larger project that may be that we would come back to the council for sometime in the future. But at this time, again, it's just collecting data that we use and analyze to determine feasibility for, again, a future project.
Thank you. Do we have any public input for this project? We'll check the Zoom room. There's no hands. All right, so we do have one hand here in the chambers. So there's a sheet in there. You can print your first and last name and say your first and last name for the record on the mic, and then you'll have 3 minutes.
Good morning, thank you. My name is Wayne Doherty. I live at 10395 Butte Rock Ranch Road, which is the parcel to the, I guess you would say to the south of the project. The towers are pretty unsightly. I hate to see them be there forever. I'm not necessarily objecting to them, but they are definitely a concern sitting there forever. And I just want to let everyone know that, hey, the neighbors are not in favor of having them sit there forever. I wish everybody could have showed up today, but due to weather and work conditions, it just didn't happen, I guess. So for my part is, yeah, they're there. They aren't really causing any harm, but they are unsightly, and I really don't want to look at them for 6 more years. So thank you.
I have a question for you, sir. Right back here. So you were notified of the project for this extension?
Yes, I got a letter from the Plan Commission saying I think this is the 3rd time they've extended it out.
Okay.
I don't know if all the neighbors were.
Oh, could you get closer to the mic?
This is the 3rd time I was notified this meeting was going to happen for this. So it's been canceled twice before for this particular setup. I think that's the reason nobody else showed up, is because it's been canceled so many times they burned out on it. But I'm just concerned that, hey, we don't want this to go on and drag out like this forever.
Okay.
I mean, they're not really hurting anything, but at the same time, we like to have some type of finite to this, not just keep it stinging it out forever on us. Okay, thank you.
Thank you.
I just have one question for you. No, excuse me. You.
The applicant.
The applicant, thank you. When you say you're doing data collection, this is for your own use, or is it data collection that you're sharing? Just clarification.
It's for the purpose of, I guess it is for our own use. We develop projects, energy projects. The parent company is called AES, and we're evaluating for a potential future project in the Morgan Valley area at some point in the future. It's still under evaluation, but yes, this is not for public, we're using it for our own uses. This is not necessarily for, I guess, public knowledge.
Okay, this is to determine whether in the future a project may be viable for that area.
Yes, ma'am.
Okay, thank you.
I guess I had a question for the staff that worked on this with the applicant. The 6-year term, was that determined based off of the applicant's request, or is it does it follow like county renewal timelines that are typical?
That was from the applicant's request.
Okay.
Yeah.
And how many times can we issue extensions for certain projects?
That I'm not sure. This is the first extension, and one thing I wanted to address at the meeting was canceled one time, but
okay.
So that may have been from,
Pulling up the reference to the code here. Looks like Article 60.33 says any permit pursuant to this chapter may be amended by the granting of a new permit of the same type following the same procedure for adoption as the original permit. Amendments to the permit may include extensions of expiration periods as provided in this other section. So I do not see a maximum or minimum amount of times, but we could also let county council.
I'm not aware of any maximums or minimums that are related to the extension of use permits that have been granted. The correct section for reapplication for an amendment for the change of the expiration date is 60.33. And there are automatic expiration dates sometimes built into the permits themselves, and more generally if the use is discontinued for 2 years. But beyond that, I think that as long as your commission can make the findings within a use permit issuance, then you, in relation to the activity you're being asked to continue, then you can certainly continue that activity or reissue the permit for another term of years.
Well, it appeared that one of the neighbors said, they're not too cute to look at, but also it wasn't really like a great concern. The time but 6 years does seem like a long time, so I would like to ask the applicant, knowing that if it's not used within 2 years, that, you know, maybe it could be taken down prior, or do you need the 6 years? Or, I'm just kind of trying to get a, kind of like a answer of how much more data and time in years that it would, that these towers would require to be up.
Yeah. So the reason that we requested an additional 6 years is because that was the back end time listed on our initial conditions of approval. And we just wanted to, you know, not waste the Lake County's time. And so, you know, I don't anticipate that these towers will be in use for an additional 6 years, but we requested that date in the interest of, again, not having to come back and
year after year.
yeah. And so, you know, I caveat that, you know, there is a chance that we use them up to 6 years, but I don't anticipate that. And ultimately they will be down once we have collected sufficient data. I would have to speak to the engineering team to figure out what the sufficient data looks like, but. Yes, ma'am.
So as part of your permit, when you remove the towers, is to return it to its natural condition?
Yes, ma'am. So when the towers are removed, they will be restored back to their previous condition, the land that it sits on.
Okay, thank you.
One last question for the applicant. So what is the timeline of data you guys collected? A little over a year and a half of data currently as we stand today?
Yes, sir.
Okay, and so just again, trying to think in terms of when your collection is done, in terms of either removal or whatever is going to happen at the backside. If you guys are done collecting data in 3 years, are you guys willing to remove the towers within 3 years? Or what does your guys' like scope of work look like? Are you going to keep it up for 6 even if you only need it for 3? Just trying to find a balance for the neighbor as well.
Yeah. I mean, I'm going to have my compatriot here.
Okay, thank you.
Hi, my name is Libby Fortin. I'm also with the applicant. So we do need the full 6 years of data to fully evaluate the feasibility of the site. And we will continue collecting even if a future project does come forth, we'll continue collecting it over the development of that project. It's part of our procedures, and in terms of the conditions of approval, that's for the original permit. That's why it was laid out as 6 years.
Thank you. Yeah, we have some hands in Zoom. All right, we'll take the first person. Callie Campbell. Please state your first and last name, and you'll be given 3 minutes.
Hi, my name is Callie Campbell. I am with the applicant. I just wanted to kind of reiterate some points that have been discussed. The 6 years that was in the conditions of approval came from the county, I believe from the Planning Commission. They were written into the conditions of approval when we received the permit. And as Brandon mentioned, we felt like it was the most efficient to just go for that full 6 years, which was already conditionally approved previously. And kind of to that point, we first submitted this permit application or extension it was either May or June of 2024, and we're just now getting in front of the Planning Commission. So we appreciate everyone's time, but those kind of delays are just concerning for us because, you know, our original permit without an extension was supposed to expire in August of last year. So we just want to make sure that we're doing everything by the book and we're all squared away. So that, and then I also wanted to clarify that the wind data we are collecting is for private use. Thank you very much.
Thank you for your comment.
Commissioners, if I may clarify, There was not a conditionally approved extension. In the conditions, there is, and I suspect it was because your predecessors who approved the permit were attempting to make it temporary, the use temporary as it was presented. But they did put in one of the conditions, and staff can provide the number of which condition that is, that there may be one extension of 6 years. No longer than 6 years. However, your past commissions cannot bind your commission. Your commission is there is the application before you to amend this particular permit. It's a reapplication for an amendment, and they're asking for an extension. So you are not necessarily bound to provide an extension or provide an extension within that time frame.
May I just ask the applicant, when you talk about future projects, what does that mean? What kind of project are you considering?
Sorry. Again, my name's Libby Fortin. So future projects we're considering is a wind facility in the area. We're in very early development stages, only looking at the meteorological data that would allow us to make a decision on whether or not a project is feasible.
You mean windmills?
Yes.
Okay.
And then one last question for you. So I believe I heard you clearly earlier, and you said if the extension is approved, also during the scope of the project or any future projects, you want the towers available. Am I hearing you correctly?
Yes, so that would be still within whatever time frame is allowed under this use permit that the commission approves. If we needed additional time, we would consider it part of that future use permit for the future project, and we would evaluate any impacts of an extension at that time.
Thank you.
Do we have anybody else in the Zoom? Okay, nobody in the Zoom. Are there any other public inputs here in the chambers? Seeing none, I'll be closing public input and bringing it back to the commission for action or discussion. Well, the project seems pretty straightforward. I leaning towards approval, depending on how you guys feel about the project.
I feel that we can approve this project. I'm concerned about the 6 years. I would be comfortable with 4, but that's up to what everyone else feels.
I'm in support of moving forward, and I think the 6 years is I mean, if we're looking at a future project out of this, I think the more data they have is important. I don't see myself being here in 6 years at this commission, so I think about that in my decision making. So I think the data that's being collected is going to drive whatever happens in the future. So I'm comfortable with the 6 years myself. Which district is this in?
This one is in Lower Lake, so District 1.
Okay.
So.
I didn't know if you had any comments.
Oh, no. I think I'm leaning with the original project as is. Move forward with it.
Okay.
So with that being said, do we have a motion?
Yeah, I'll make the motion. I move that the Planning Commission find major use permit UP 24-14, amending UP 22-06, does meet the requirements of section 51.4 and 60.33 of the Lake County zoning ordinance, and grant major use permit UP 24-14, subject to the conditions and with the findings listed in the staff reports dated February 15, 2025 and August 25th, 2022.
A second.
Motion and a second. All in favor?
Aye.
Aye.
Aye. All opposed? And the motion passes. Thank you. Note, the applicant or any interested person is reminded that the zoning ordinance provides for a 7 calendar day appeal period. If there's a disagreement with the Planning Commission, an appeal to the Board of Supervisors may be filed. The appropriate forms and applicable fee must be submitted prior to 5 p.m. on or before the 7th calendar day following the Commission's final determination.
Chair Chavez, could I request just a 5-minute break, please?
Yes, of course. So it is 11:10 a.m., so we'll come back at 11:15. and welcome back. We'll be moving on to our next timed item, our 9:35 a.m. public hearing, consideration of general plan conformity determination, GPC 24-01, and CEQA categorical exemption, CE 24-41, to remodel the National Guard Armory to the Sheriff's Administration Facility, located at 1431 Hoyt Avenue in Lakeport, APN 003-045-75. And staff.
Good morning, Commissioners. Pablo Guerrero from Lake County Community Development Department. I'm here to present the general plan conformity, and there's also a representative present in chambers as well for the application. So request and project proposal, approval for remodeling and expansion of the National Guard Army into the Lake County Sheriff Administration Facility. Approval for additional square footage, building modifications and infrastructure updates. Enhance public safety through office spaces, law enforcement, training center, and public services. Compliance with the general plan to be determined by Planning Commission. Site description, the parcel size is approximately 7.08 acres. It's zoned open space. The general plan destination is public facilities, a supervisorial district 4. It's accessible via Hill Road, which is a county maintained road, which is near Highway 29, approximately 985 feet away. The facility layout, so the existing building is 20,323 square feet. The proposal is an expansion of 578 square feet, totaling of 20,901 square feet. A second floor will be added, which would increase the roof height to 26 feet and 8 inches from the original 23 and 8 inches. So it would be an increase of 3 inches in the total from the roof, which would increase the total square footage of 3,496 for the second floor. For parking, there's 166 total parking spaces. Within those includes the additions of 4 electric vehicle charging stations and 8 ADA compliant parking spaces. For the project analysis, reviewed the Lake County General Plan. The goal for that is to establish and maintain a sustainable and safe levels of service, minimize costs, provide criteria for determining the location, capacity, and timing of future public service facilities and services. A policy under that is PFS 1.2, locational criteria for public facilities. Facility supports community engagement through law enforcement, operations, employee training, and public services. There's minimal traffic impact, less than 110 trips per day, below the CEQA significance threshold. Another policy is a PFS 1.3, maintain existing service levels integrated with the water and sewer systems. Infrastructure is sufficient for current demand, and future usage may prompt adjustments. For the project analysis for the Lakeport area plan, the additional square footage, which includes new offices, a second floor, will provide accommodation for more deputies, administration staff, and training personnel, thereby improving the Lake County's ability to addressing the increasing public safety demands by expanding and modernizing law enforcement infrastructure for current and future needs in the Lakeport area. It would be a central hub for law enforcement in Lakeport, which supports Objective 5.41 to upgrade fire protection and law enforcement in the planning area. The proposed project would therefore conform with the Lakeport area plan. Reviewing the Lake County zoning ordinance under Article 2, it says that it states that Article 2, Section 2.4b, exemption subsection 4, any development undertaken by the County of Lake is exempted. Thus, any proposed development must adhere to the Lake County General Plan. However, the Lake County must continue to ensure full compliance with any applicable federal and state regulations. The environmental review. So pursuant to CEQA, Section 15301E1, Class 1, an exemption applies to projects where proposed additions to existing structures do not exceed 2,500 square feet. this exemption applies to this GPC because the additions of 578 square feet is below the 2,500 square feet limit. Recommendations from staff. So the general plan of conformity recommendations: adopt CE 24-41, a categorical exemption from CEQA under sections 15301, class 1, E1, existing facilities, and approve GPC 24-01 with the findings found in the staff report. And if you have any questions for me, that's my presentation.
Thank you very much. Great presentation. Do we have any questions from the commission? No questions. So I'll be opening up public input. If anybody in the public would like to speak, please write your name legibly on the paper and state your first and last name for the record.
Good morning. My name is Tom Horton, and I am the owner of the private property adjacent mentioned in the staff report. I just have one request, and I don't know if this is the right venue for it, but the existing facility for some reason has floodlights, pretty strong ones, that beam straight up to my house, and my house is actually above the level of the building, so I'm not sure why they do it that way. But if it's at all possible, if it comports with the project's goals and doesn't bust the budget, I would request that they be reoriented such that they don't beam at my house. That's my request. Thank you.
Thank you for your comment. We'll have staff look into that. So once the project goes through the building,
We'll definitely make note of that as it's going further.
okay, thank you. All right, state your first and last name for the record, please.
My name's Joe Cooper. I'm the capital projects manager for the public services. So the lights that are pointing into Mr. Horton's property are currently high pressure sodium or metal halide, but very bright and unshielded. The new lights that are proposed will be direct light LED that will be facing downward and shielded to his property. So in the plans of the project, his concerns are addressed.
Very well, thank you very much. Do we have any other questions for the applicant or for the staff? All right, so I'm gonna keep looking into Zoom to see if there's any hands. All right, I see no hands in the Zoom room, and anybody else in the chambers? One last look. So we'll be closing, excuse me, we'll be closing public input and bringing it back to the commission for action.
So I'll make the motion. I move that the planning commission determine the proposed remodel expansion of the National Guard Armory into the Sheriff's Administration facility exempt from CEQA under the California Code of Regulations, Title 14, Division 6, Chapter 3, Article 19, Section 15301, existing facilities, Class 1E1, with findings in the staff report dated February 13, 2025.
Second.
Got a motion and a second. All in favor?
Aye.
Aye. All opposed? Motion passes.
The general plan conformity, I move that the planning commission finds that the remodel expansion of the National Guard Armory to the Sheriff's Administration facility as proposed by the Lake County Public Services Facilities Maintenance Division is in conformity with the Lake County General Plan as required under California Code of Regulations, Section 65402, with the findings in the staff report dated February 13, 2025.
Second.
Motion and a second. All in favor?
Aye.
Aye.
All opposed? None, and the motion passes. Note, the applicant or any interested person is reminded that the zoning ordinance provides for a 7-calendar-day appeal period. If there's a disagreement with the Planning Commission's recommendation, an appeal to the Board of Supervisors may be filed. The appropriate forms and applicable fee must be submitted prior to 5 p.m. on or before the 7th calendar day following the Commission's determination. All right, thank you, staff. Thank you. And moving on to, moving on to our next item, which is non-timed items. None of those. Department update.
Thank you. I'd like to start with a congratulations to Pablo. Was his first Planning Commission presentation. I know, you almost got out of here. Professional development is a high priority of our department, and we are all very, very pleased with how Pablo's job knowledge has progressed during his time here. So he's a good part of our team. All right, you can go now, Pablo.
Enough embarrassment.
Right. Secondly, at the last meeting, the Board of Supervisors appointed Monica Rosenthal for Planning Commissioner District 1 and Miley Field for Planning Commissioner District 4. They will be ready to join us, get sworn in at our next Planning Commission meeting. So we're very excited about that. And then lastly, we are having, for Lake County 2050 update, we're having a General Plan Advisory Committee meeting today at 3 o'clock in the board chambers here. We will be discussing the LAPAC recommendations for land use designation amendments. This is probably the meatiest part of the mapping recommendations from all the LAPACs. And so because we don't want to rush the General Plan Advisory Committee in their deliberation, we split up the mapping recommendations into 2 meetings. So today will be the first one. The next meeting will be on Thursday, February 20th, again here and again at 3 o'clock. And the topics for that meeting will be to consider LAPAC recommendations for community growth boundaries and planning area boundary amendments. Just an update on the overall timeline. Our timeline for getting our public review drafts of all countywide documents and updated local area plans has been moved back a little bit to, we're now looking at late summer to early fall. And at that point, or a little before that, we're going to reach out to our municipal advisory committees, since they're well positioned all over the lake, and people look to them already in the community for their input, and see if we can piggyback on some of their agendas in order to have hearings all around the lake for LAPAC consideration of any needed edits. So, still going. Things are awesome. Yeah.
I just like to say that it's really wonderful that you come to the area planning meetings. I wish they were better attended, but the information that you share is really important in this whole process. So
Thank you.
Thank you.
Yeah, we can't have a community vision without hanging out with the community. Thanks. That concludes my update.
Is there another update regarding the building department or CDD upstairs? I heard something on the Board of Supervisors meeting.
Oh, my word. All right, so, well, yes, I do have an update, but I didn't bring it with me. The governance workshop is a great opportunity where the board has an annual hearing for all of the different department heads to come and tell them what we accomplished last year that we're really proud about, what we're looking forward to next year. Suffice it to say that a good chunk of my presentation of the board was accurate, but it was brought to my attention afterwards that I used the 2023 stuff we were really proud about and resold it to the board as 2024 data. So I would be happy to bring the actual accurate information to the Planning Commission at our next department update so that you will have the right info. I'm getting over my mortification, but it's not quite done.
That wasn't what I was referring, but thank
Oh,
you for that
oh,
update as well.
oh, bared my soul for no reason.
Sorry about that, Maria.
It was awful.
All right. So with that being said, we adjourn this meeting today at 11:29. Thank you.